Power of attorney is a legal document that allows someone to act on your behalf when you are incapable of making the decisions on your behalf. It is very important to have a power of attorney because in a situation where you become incapacitated to make certain decisions, there is someone who can act in your best interest and make those decisions for you, keeping in mind what your wishes were. Power of attorney is of two kinds. One is power of attorney of personal care and one is power of attorney for finances. So power of attorney for personal care deals with all the issues and areas involving personal care of a person. It can be bathing, medication, living, clothing, all that kind of stuff. Whereas the financial is very clear. It deals with all the financial aspects of the person. One of the biggest factor is that when you are making power of attorney for personal care, you have to make sure that the person you nominate should be 16 years of age, and for the power of attorney for finances, the person you nominate should be at least 18 years of age and over. It is very important to make sure that the person you are considering as your power of attorney should be mentally capable to make the right decisions for you, and secondly, the person should not be paid. So the same goes for the power of attorney for finances, that the person should be mentally capable to take care of your finances in your best interest, and secondly, the person should not be in any paid capacity. While choosing a power of attorney, it is very important to choose the person whom you trust. That is the first and the foremost thing. You should be able to rely on that person, that in case something happens to you, this person is going to take care of your wishes in the best possible ways. And secondly, you should also consider about the experience that person has in making all the decisions that you would like to make if it was you. If you don't have a power of attorney, then in that case, a family member will be making those decisions for you. And in case there is no family member or there is no person who is capable to make the decision, then in that case, the Office of Public Guardian and Trustee takes over. A will is a legal document that makes sure that your property and your estate is distributed, keeping in mind your wishes. It is very important to have a will. In case of absence of a will, your property and possessions will be distributed keeping in mind the law of the province. Also, in case you have some joint properties and you don't have a will, then automatically the property will be transferred to the other stakeholder automatically. While making a will, there are a couple of things that you should consider. First is make a list of all your assets and liabilities. Second, who will be your beneficiaries, and third, who is going to be your executor. Executor is a person who is responsible to execute the will. There are a couple of factors that are very important while deciding the executor: their age, their health, the place where they live, their financial stability, and their ability to manage all the affairs. So these are a couple of things that are very important to keep in mind when deciding on an executor. You can always change your will till you are mentally capable, and if you ever feel that you want to change your stakeholders or you want to make your decisions differently, you can always do that, but make sure that you revoke your previous will. Probate is a process that confirms the will and executor authority to distribute assets of the deceased estates. You can get a will made by lawyers. There are lawyers out there in the community who would do this. There is little charge to it, but you know that by getting services of a lawyer, you are at least making the best decisions, keeping in mind your finances.